So we're going to talk about the various types of dispute resolution that are available to business, and we're going to try and position the main thing that you guys are talking about, which is litigation, against other things that are available. So after this, you will hopefully have some appreciation of what we're trying, how parties in a business or commercial context can try and resolve arguments that they've got with each other in a nice, cost-effective way without actually ending up in the courts and having to hire lawyers and all the rest of it. Now, this is probably sounding a little bit weird to the majority of you, because first-year students, especially, are assaulted with all this information about courts and litigation and all of these processes. And because you hear so much of it, you get the impression, or you might be left with the impression, that the only way that you can deal with a problem is by getting legal advice and then going to a court to resolve the issue with the other party if the other party does not accept your point of view. You saw everything through case law and through this process of people having an argument and resolving it through the courts. The reality of business life, though, is nothing at all like this. The one thing that people are trying to avoid, they try to avoid going to court as much as possible. And in fact, the funny thing is that if you do end up in court, the actual process of the court looks nothing like you think it's going to look like. You think that court cases are about barristers sitting there reciting ancient cases. It's not like that at all. It looks like that to you because all the cases that you come across are Court of Appeal or Supreme Court cases, because you're trying to learn what the law is. When you're in an actual courtroom, they already know what the law is. So they're not arguing about the law, they're arguing about the facts. So everything in a court, in a normal court where a case is getting dealt with, is about establishing the facts. So this was a shock to me when I was a student and I went to sit in a few courtrooms, nobody said anything about the law. Like, everybody just assumed that everybody else knows what they're talking about, and the whole discussion was who said what to whom and who did what and in what sequence happened and all of that stuff. It was really strange to me. And it also might tell you whether this is the sort of career that you want to pursue. It could be that you see people in a courtroom representing clients and you find it very exciting. Or it could be that you realize it's got nothing to do with the stuff that you saw on TV, therefore this is probably not something that you're that attracted to. But the one important thing that we've got, though, is a really intense desire to stay as far away from the courts as humanly possible. And the reason for this is the cost. Going to a court and going through a litigation process is evidence of failure. Something has gone wrong. When you were doing contracts, you saw all these things that one party alleges that the other one has breached the contract because they did not get what they were expecting, or the quality of some service is substandard, or something has been done not according to specification, and so on. The normal way to address this would be to discuss with the other party and say, hang on a second here, we said you were going to do this for me, you produced something different, can you please fix it? If the other party says, I think I did what we said we were going to do, or there is some misunderstanding about what we were doing, then this is again something that you should be able to work through. If you get to the point that the other party says, I don't agree with you, I think I've done my job perfectly, I don't understand what your problem is, if you got any problems, sue me, and you reach that level of breakdown, then you are in a situation that you might end up in a courtroom. We are doing this in a business commercial setting. I'm not talking about tort actions where you suffer damage, then you're trying to go after the other party because, say, the neighbor wasn't taking care of their tree and it fell and it kind of ruined your car or ruined your garden, right? Or it did like a wall in your house. I'm not talking about that kind of stuff because that stuff inevitably ends up in the courts. And I'm not talking about the consequences of criminal activity because you can always, if somebody burglars you and you know who it is, right, then you can sue them in a civil court for compensation for the stuff that they've stolen from you. Yeah? Again, this is something that inevitably will involve the courts. But the commercial business side of things, that is mostly about contracts not being performed in the way that people were expecting. So it's about kind of a mismatch of expectations. This is something that you should be able to find other ways to address rather than the trouble of getting a lawyer, getting legal advice, getting the lawyer to represent you, ending up in a courtroom, having all the costs of paying the lawyers, paying the court, and going through a lengthy process. Now, the system here is relatively efficient in the sense that you will, if you file for an action, you will have resolution of it within a reasonable time frame. It might take a year, but it's not the end of the world. Complicated cases might take more than a year, but you can see an end of the process somewhere. So if your builder has done some work that is inappropriate, then you can probably kind of handle a year to get some resolution, especially if the cost of remedial work runs in the tens of thousands of pounds. In other jurisdictions, though, where the court systems are less, if this incentive against using the courts is time in itself. So if you go a construction dispute and you want to sue your contractor and you file in court and they give you a hearing date in 3 years' time, and then you know that once you got your first hearing, then it's going to be another 3 years before you have a decision, then it renders the whole attempt to resolve this through the courts pointless. Because if you're looking at the resolution to such an issue in 6, 7, 8 years' time, by that time the contractor will probably have gone out of business, right? Or you might have gone out of business. I mean, you cannot project far. If you're talking about issues of financial compensation, you cannot wait 6, 7, 8 years. In all probability, the entity will not exist. They will have gone bankrupt, so you're doing all these things for nothing. And if you're dealing with a really dodgy contractor, there's much chance that they're going to be around for very long anyway. Yeah. So if the system is not efficient enough to be able to resolve the dispute in a complete way within an adequate time frame, then this is not a viable way to resolve business problems. So especially if you're talking about problems that you've got with somebody that operates abroad and involves other legal systems or courts in other jurisdictions, then you will have to think very carefully whether this is the type of dispute that you want to take to a court. Or it could be that the complexity of the dispute is such that it will take forever. So you get complex fraud cases, you get complex financial claims that take years and years and years to resolve in the courts because the task is simply too big. So working through what happened takes years. You usually come across this in terms of prosecutions. Think about the LIBOR scandal, which was a manipulation between banks in setting interest rates and so on. This was a fraud case, so this is like a criminal. There's the criminal aspect of the law. It took forever, not because the courts didn't feel like doing it, but because it was such a complex thing to do. They needed to go through so much paperwork. They needed to talk to so many witnesses. So if you've got something that is going to take forever. Now, if you have something also that the courts do not have the capacity to understand and resolve properly, then you end up in trouble. Courts are very capable of dealing with predictable types of arguments. I mean, you've got lots of construction disputes, you've got lots of kind of supplier failures, you've got lots of mismatches when products have got a problem with them. The courts I have no issues in understanding this. But if you've got a dispute about some kind of weird Bitcoin transaction, right, that has got elements of both kind of civil law and criminal law within it, and it's about financial instruments containing technologies that nobody understands, you shouldn't take for granted the capacity of the judges to understand this. If this is the sort of stuff that only a few insiders and you need expert advice, and there are very few experts that understand what this is, you shouldn't automatically assume that your standard kind of commercial law judge sitting in a court here will be able to get on top of this information. And if the judges cannot understand what's happening, then it's going to take a lot longer. We don't have juries here in civil jurisdiction, in civil cases. So if we're talking about civil cases, the concern is not, can the jury understand what's happening? right? We don't have them. So this is more a concern for other jurisdictions like the US. Here, juvenile fraud cases where the jury might have difficulty understanding what the hell is going on. So it's more the capacity of the judges to understand what's happening in order to resolve the disputes appropriately. So all these reasons give you a fair summary of why you might want to stay away from the courts. Issues of cost, issues of complexity, issues of availability of the courts. All of these will be whether you want to solve if this is not solved. And most of the time, people are really worried about legal, because if you end up in court for complex, you need legal advice, and legal advice. We've established why litigation might not necessarily be the best way to fix problems. So if you go with that, what else do you have? We've got all these things that come under the big label of alternative dispute resolution. Why alternative? Because it's not litigation, right? So on the one side you've got litigation, right? So on the one side you've got litigation, and on the other side you've got everything else. Everything else comes under this label of alternative. Now there are lots of those, and maybe some of those you may have actually used yourselves. There's a whole that start from simple and cheap, and then they progressively become more complex and more involved and perhaps more expensive till you get to the point that you end up in a court somewhere. From your customer interactions and your normal sort of consumer perspective, you have probably come across the idea of an ombudsman that has to do with a particular service that you're using. You guys ever heard of the ombudsman before? It could be an ombudsman or an ombudswoman. It seems like a strange term, doesn't it? This is some sort of informal, friendly resolution service primarily geared towards consumer disputes in particular industries. For instance, booking a ticket. And as you're booking the ticket, you're booking yourself a holiday, right? You go on kind of last minute or Expedia and so on. You pick of course now nobody's traveling anywhere anymore, but you book your flight, you book your car rental, you book your hotel, you book your car rental, you book your hotel. The thing matches it all together, gives you a price. Okay? Right. You press pay. 10 minutes after, you get the confirmation there, and then email just to check. It's charged you something else. Hang on a second. What's going on here? If it gives you a price, you've all done this before, right? You've all booked something, haven't you? When it gives you a price, just here's the total price, and then put in your credit card details or whatever, that's it, right? You shouldn't be, that's it, right? You shouldn't be charged anything else. Now, what is the legal reason why you shouldn't be charged anything else? Is that according to the Consumer Rights Act, if you're making an electronic transaction online, the final page before you put in your payment information is required by law to be the total price with any additional charges. If there's anything flexible about this, it needs to be clearly laid out. Sometimes there is something flexible about this. It could be if you do your mobile phone contract, for instance, the contract might contain a term that has got variation. Of terms which might include variation of prices, and it does happen, right? However, the price that it gives you there and then needs to be clearly presented to the customer. So if you're getting a new contract and it's £20 a month, right? It might contain a variation, but when you clicked on 20, you get in 20. So today, you should receive a confirmation that says you got a contract that says £20 a month. If the confirmation says 40, we have a problem, and this is against the Consumer Rights Act. The rights that you've got under the Consumer Rights Act are to cancel this transaction, or for the company to give you what is transaction, or for the company to give you what it is. That's your selection. Right? Now, That's the law, that's the legal background. But the reality of the matter is, you were trying to engage in some transaction and you got something that appears to be an error. You call the company right away and you say, you send me a different price. If they say, no, I'm sorry, that's the price meant be, I don't know what it is that you saw, right? But the price for this product, and now it's a non-refundable ticket, so now you booked the whole thing, there's nothing we can do about it. And if you tell them, no, and if you tell them, no, because that's not what you showed me, this is not what I got charged at the back, and this is a problem for you because this is a violation of my rights, and I want you to do something about it. If they say, no, we think you got this wrong, we cannot help you any further, that's it. Theoretically, you can go to the small claims court and file a claim right away, right? And say that I've been, let's not worry about how you prove it, right? If you're, if it happened to you before, like it's happened to me on a few occasions, you would probably, it's a good idea to take a screenshot of the payment page before you actually put your payment information in, right? So that's always a good thing to do, or kind of print a PDF of the last thing that they've got before you need to pay for it. That way you can prove it. But let's not worry about issues of proof at the moment. The thing is, you thought you were doing something. There was nothing wrong with what you were doing. They made some sort of mistake in their computer system and something else. You've been charged something else. You can go to the small claims court, but this is going to be anxious for you because you're going to be thinking, have I understood this correctly, right? Do I need to talk to a lawyer or not? If I go to the court, am I obligated to have a lawyer? I don't know. You're not actually. And I'm going to have to pay something in order to file in the court. And what happens if I misunderstood all this? So not only now I've got a holiday that I'm paying more than I bargained for, but I've also paid like £100 to the court to file the action. And who the hell knows how else it's going to cost? It's going to cause you anxiety, right? Or it's going to cause you some level of kind of doing research to figure out how to access this part of the court if you haven't done it. One of the things that we're less good at in law, if you're doing an undergraduate law degree, is that we know about the practicalities of it. We attempt to teach you things about the substance of the rules, but we don't teach you the mechanics of accessing it. Meaning that everybody graduates here with a law degree, nobody has a clue how to file in court. That's the kind of stuff that you do when you go do the LPC or something like this, yeah? So we're ignorant of the mechanics. Even when something happens to us personally, and we're all people with kind of law degrees and surrounded by lawyers, nobody can help you with anything practical. That's a problem. Putting that aside, what about all this ombudsman stuff, right? Because when you're on the website of the travel agent, it says at the bottom, we're members of this, that, and the other thing. This is for complaints. This is for insurance in case we go bankrupt. This is for insurance in case the airline goes bankrupt. All this stuff, right? There are all these logos and things at the bottom that's supposed to make you feel better. So you might think, okay, if this is like an external complaint thing, why don't I go and complain and tell them what they've done to me? So that is the number one level of choosing an alternative route from going to a court in order to complain. If you go to the ombudsman services are built on an industry basis. So the travel agents have got one. The insurance companies have got the opticians have got another one. So these things facilitate complaints. Crucially, they're free to you. So you don't have to worry about it. It's a simple process. Somebody happened. You don't need legal representation. They're the ones who are going to explain you what your legal rights are. The only thing you need to do in to explain you what your legal rights are. The only thing you need to do in accessing these services are for you to be able and to provide evidence that you've got to back up. You don't have the law, you have representation, and it's of no cost to the customer because it's funded by the industry. They will say you can access this after you've exhausted the internal complaint processes. They will do this because they don't. The pool's not clean, and they didn't like their bed at the hotel and all that stuff. But you have gone through the internal process. And the way you do this is that you call them, you told them there's a problem, they said there's nothing they can do, you ask to escalate, they again told you there's nothing you can do, then you have to tell them, according to the information you get in these things, that I want final decision because I intend to go to the ombudsman. and then it gets pushed to somebody higher up in the management, and maybe they will have another look at it, maybe not. In my experience, the vast majority of the internal complaints process is get bored and leave us alone. So they'll say no, 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 and nobody even reads what it is that you're complaining about till you say you're going to go to the ombudsman. At that point, they're going to read what you're complaining about and still say no. Then you go to the ombudsman, submit everything, sit back and relax. In a couple of months' time, you're going to get an email by saying, I'm the person who's been appointed to look at your complaint and so on, at which point the company is going to fold and compensate you. Because if we're talking small amounts of money, you're arguing what? 50, 100 pounds. The time it takes for the company to have a proper look at it is more expensive than the value of your claim. So once the ombudsman communicates your claim to them, most of the time they'll come back and... Now, if you got a more substantial claim that runs into a few £100, then if you're right, and the ombudsman communicates that you're right, if the response from the company is inappropriate, right, the ombudsman is going to say, we find that the company has done something wrong. If the company still refuses to compensate, then you have very good grounds to take them to court. The problem with the ombudsman is that this is a conciliatory, friendly arrangement. The ombudsman has no enforcement powers over the company. So if the ombudsman finds that the company has done something wrong, and the company refuses to address this, then they cannot make them. But then you know that an external party has looked at your problem and agrees with you, and agrees that you've got the evidence to back it up, which puts you in a much better position to file in court. We'll go that way. But what I'm trying to demonstrate here is that all this actually usable stuff. This is not theoretical, right? This is actual stuff. And all right, why not try it? What you got to lose? It's free. I mean, I'm not saying that you're going to do it for harassment, right? So you need something needs. I'm telling you, it's really stuff that happens all the time. You put like a discount code, right? And then their invoice says something else. It's like, well, you should go with it. Your attitude most of the time is, yeah, fuck it, it's just £10. Why? If it's an error on their part, you should pursue it. Now, we have other things though. So the ombudsman facing stuff. What if this is a business transaction? If it's a business transaction, like an ombudsman thing is not really going to be suitable for you. What you want is a third party to sit down and discuss, to be a go-between in helping you mediate the problem, right? Because most of arguments are due to a failure in communication. And you know this from your personal lives where you're arguing with your boyfriends and girlfriends and stuff, right? It's the failure to communicate to the other party what it is that you want that causes this mismatch of expectations. Therefore, the idea is that instead of you kind of going nuts and hiring lawyers and running to the court, if you could just sit down with the other party and have an independent third party listen to you, if you try to explain your situation, not to the party with whom you're pissed off, you have a problem with your contractors, right, and you hate them, it makes it difficult to communicate what your problem is if you're in a tense personal relationship. If you've got a third party present, your attempt to explain to the third party what happened and to listen to the explanation of the other side might help you to reach a resolution. So these come under the umbrellas of adjudication, or conciliation, or mediation. This is a very well-established system of having a third independent party to sit down and assist two sides that are arguing over something. The crucial thing about this works for consumer issues, but mostly suitable for commercial business issues. The important thing is that this is a process where the people are reaching a negotiated settlement, meaning that the third party has got no enforcement powers. So if they agree to disagree, then there's nothing they can do. Or if the mediator agrees with one side and disagrees with the other, they've got no way to make the other side do anything. So all of these, ombudsman, mediation, conciliation, adjudication, are ways in assisting people to resolve the issue by themselves. And by the way, to go back to my ombudsman example, what I had in the end was a recommendation from the ombudsman as to what should happen, and then an offer from the company. The company said, we'll agree to pay you that amount. Are you okay with that? To drop your complaint. So you reach a negotiated settlement as the result of all this process. If a negotiated settlement is not what you want, and you want somebody with enforcement powers that makes a decision as to who's right and who is wrong, but you don't want to go to the court, then what you got left is arbitration. Now, arbitration is a way of resolving disputes, and it leads to a why arbitration more closely resembles litigation because it's a final decision-making process. The thing about arbitration is a final decision-making process, meaning that both parties agree to give to a third party the power to decide what to do. And this is not like, okay, I say I'm gonna do what you tell me to do, and if I disagree in the end, I'm not gonna do it, because the law gives the enforcement powers of the court to the arbitration. So the people who run the arbitration, they're called the arbitral tribunal. So on the basis of the Arbitration Act of 1996, the Arbitration Tribunal has the same enforcement powers as the court. The court will not touch it. If you've signed an arbitration agreement that says, if we got any problem, we go to arbitration, you cannot go to the court. If you turn up at the court, the other person is going to say, no, we said we have an arbitration agreement, and the court's going to say, sorry guys, you said you were going to arbitrate, now you have to go arbitrate. And whatever outcome you've got from the arbitration, if you refuse to comply, then they're going to come, show us the decision of the tribunal, and us, the court, are going to send in the bailiffs. So you basically subcontract, if you want, the decision-making and the enforcement power of the court, and you're passing it on to the arbitral tribunal. So going to arbitration requires agreement by the parties. This agreement is either present in the original contract. There are lots of contracts that say, in case of argument, we go to arbitration, and arbitration is run by somebody over there. Or it could be that after the dispute arises, you're thinking, okay, we're not going to resolve this between us by talking to each other. We want somebody else to figure it out. How about we go to arbitration and we sign the agreement there and then? But in the whole array of alternative dispute resolution that we've got, it's important for you guys to remember the distinction between things that are talking shops or opportunities to talk in a structured way that arrive at a negotiated settlement, and the final decision-making processes like arbitration in the courts. So what we can do, and obviously all this has got very secure legislative basis. For arbitration, we've got the Arbitration Act of 96 as this most modern expression, but we've got the Alternative Dispute Resolution Directive, which is a relatively more recent legal instrument that gives legal basis to this whole universe of different ways of resolving